Agreement to agree on rental rate is unenforceable issue. Under the 3-year written lease, the tenant has an option to renew for an additional 3 years. This option does not provide for a specific rental rate, however, but simply states that the landlord and the tenant will negotiate the rental rate. Is this option to renew the lease enforceable by the tenant? Answer: probably not. In general, an agreement to agree on material terms in a contract renders the contract unenforceable. Therefore, the option to renew for an additional 3 years based on the rental rate to be negotiated between the landlord and the tenant is probably not enforceable by the tenant. See Cecil Lauder Real Estate School, Inc. v. Town and Country Shopping Center, Commencer Lauded, 143 Eras 527, 694, P2D 815, Eras App 1984. Note: although the tenant can probably not enforce the option to renew the lease for 3 years, the landlord and tenant obviously can agree on a rental rate. Bedbugs are gross. Facts: a tenant of a single-family residence who has resided at the property for more than 3 years contacted the property manager to advise her that the property has bedbugs. Issue: who is responsible for taking care of the bedbug infestation? Answer: the Arizona Residential Landlord and Tenant Act now contain a section concerning bedbugs under ARS, paragraph 33, 1319. Unfortunately, the statute does not address who is responsible for resolving an active infestation. Generally speaking, if the bedbugs were present when the tenant rented the property, then it is the landlord's obligation to treat the infestation. However, if the infestation happened during the tenant's occupancy and was the tenant's fault, then it is the tenant's obligation to alleviate the problem. Documentation may be requested for an assistive animal X. A residential property manager received an application from a tenant who is requesting reasonable accommodations to have an emotional support animal in the property. The property manager requested documentation from the prospective tenant's doctor indicating the tenant would benefit from an emotional support animal. Issue: can the property manager ask for documentation from the tenant indicating the tenant would benefit from an emotional support animal? Answer: see discussion. Discussion: housing discrimination against persons with disabilities is prohibited under federal law. The U.S. Department of Housing and Urban Development Office issued a letter on the topic of service animals, which provides the following. Housing providers may ask individuals who have disabilities that are not readily apparent or known to the provider to submit reliable documentation of a disability and their disability-related need for an assistance animal. If the disability is readily apparent or known, but the disability-related need for the assistance animal is not, the housing provider may ask the individual to provide documentation of the disability-related need for an assistance animal. For example, the housing provider may ask persons who are seeking a reasonable accommodation for an assistance animal that provides emotional support to provide documentation from a physician, psychiatrist, social worker, or other mental health professionals that the animal provides emotional support that alleviates one or more of the identified symptoms or effects of an existing disability. Such documentation is sufficient if it establishes that an individual has a disability and that the animal in question will provide some type of disability-related assistance or emotional support. However, a housing provider may not ask a tenant or applicant to provide documentation showing the disability or disability-related need for an assistance animal if the disability or disability-related need is readily apparent or already known to the provider. For example, persons who are blind or have low vision may not be asked to provide documentation of their disability or their disability-related need for a guide dog. A housing provider also may not ask an applicant or tenant to provide access to medical records or medical providers, or provide detailed or extensive information or documentation of a person's physical or mental impairments. Generally, after the tenant's death, the lease is enforceable against the tenant's estate. Facts: a tenant passes away with 8 months left on his lease term. Issue: does the lease terminate upon the death of the tenant? Answer: In general, contracts such as leases and purchase contracts are enforceable against a deceased party's estate. The landlord, however, has the affirmative obligation to make reasonable efforts to find another tenant for the remaining 8 months of the lease. If the landlord is not able to find another tenant, the landlord has a claim for rent against the tenant's estate. Sue note girlfriend, entitled to terminate lease after domestic violence, by boyfriend issue. A girlfriend and her boyfriend recently signed a 1-year lease. Last week, there was a violent domestic dispute, and after the police were called, the girlfriend moved out. The property manager has now received a notice from the girlfriend, along with a copy of the police report, demanding that the property manager terminate the lease as to the girlfriend and return the girlfriend's portion of the security deposit. Is the girlfriend entitled to terminate the lease and get her portion of the security deposit? Answer: probably. ARS Paragraph 33, 1318A provides that, in the event of a domestic dispute, the party moving out is entitled to terminate the lease with a 30-day notice and a copy of the police report. At the time of termination, that party should also be entitled to receive their portion of the security deposit. If the landlord is not paying HOA fees and the HOA prohibits the tenant from using of HOA facilities, the landlord is in breach of the lease issue. Under the lease agreement, the landlord is required to pay the monthly HOA fees. The landlord has not paid these HOA fees for several months, however, and the HOA has restricted the tenant and his family from the use of the swimming pool and community center. Can the HOA restrict the use by the tenant of the HOA facilities when the landlord is delinquent on the HOA's monthly fees? Answer: probably. The CC&Rs of many HOAs restrict the use of HOA facilities if the HOA fees are not paid. The tenant, however, is entitled to terminate the lease because of the landlord's failure to pay the HOA's monthly fees. Therefore, if the landlord fails to bring the HOA fees current after 10 days' notice from the tenant can terminate the lease. CARS, Paragraph 33, 1361. Landlord not required to compensate tenant for showings. Facts: John, a tenant, has notified his landlord that he will not be renewing his lease. The landlord lists the property for rent on the local MLS. The landlord contacts John to provide a 48-hour notice, stating that the landlord will show the property to a prospective tenant. John states that, by law, the landlord must compensate John for access to the property each time the property is shown. Issue: must the landlord compensate John each time the property is shown? Answer: no. Discussion: pursuant to ARS, Growth 33, 1343A, the tenant shall not unreasonably withhold consent to the landlord to enter into the dwelling unit in order to exhibit the dwelling unit to prospective tenants. Therefore, the law does not require a landlord to compensate a tenant for access to show the property to prospective tenants. As such, the landlord is not required to compensate John for showings absent some other mutual agreement. Landlord not entitled to damages. If a replacement tenant is found. Immediately. Facts: the tenant informed the property manager that he felt unsafe at the property. He also provided a copy of a police report evidencing a recent car break-in. Shortly thereafter, the tenant vacated the premises. At the time, rent was paid for the remainder of the month, and the property was left in good condition with no damage. The landlord was able to place a new tenant at the beginning of the next rental period. Issue: is the landlord entitled to keep the tenant's security deposit? Answer: no discussion. Although the tenant may have been concerned with the safety of the neighborhood, the facts as described dictate that the tenant likely breached the lease and is responsible for the remaining lease term, including monthly rent payments. The tenant's obligation, however, is contingent upon the landlord's duty to mitigate damages. In this case, the landlord was able to re-let the premises without any lapse in time between rental periods. If the new rental rate equals or exceeds the prior rental amount paid by the former tenant, then the landlord has no recoverable damages, and withholding the tenant's security deposit would constitute a violation of ARS, paragraph 33, 11321d, and entitle the tenant to maintain an action for treble damages under the statute. For these reasons, the security deposit should be returned to the former tenant. Lead-based paint disclosure required in residential leases if the property was built prior to 1978. Facts: the landlord and tenant entered into a residential lease agreement for a single-family residence built in 1956. The landlord refuses to provide a lead-based paint disclosure, claiming that it does not apply to rental properties. Issue: does the lead-based paint disclosure apply to rental properties? Answer: yes. Discussion: the lead-based paint disclosure must be provided for both sales and leases if the home was constructed prior to 1978. Moreover, lines 173 to 184 of the residential lease agreement contractually obligate the landlord to provide the lead-based paint disclosure.